We are back to it, part four. We're talking about removal proceedings. Remember, we said that we are going to be making a series of 10 videos on removal proceedings, strategies, practical tips, defenses, you name them. We're going to talk about removal proceedings in detail. My name is Bijoux Ngwanda, as you know it. I am an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex US immigration law cases. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like. Don't forget to comment below. Also follow me on all platforms. Links are in the description box below. Today's video, we are going to be talking about bond hearings. How to get a person released from detention center by way of bond or by way of parole or just on their own recognizance. Okay, we're going to talk about bond hearings. Well, we're going to start first with this bad news. Murder of Yajure-Explained. I talked about it in my previous videos on TikTok. I believe I posted the video again here on YouTube, or maybe we did a live session where I talked about it in detail. But I'm going to just give you what this decision means for certain individuals. Essentially, what the decision of murder of Yajure-Explained is saying is that when a person is on the American soil in the United States, and that person happened to enter in America without inspection, what other people say illegal entry. I mean, just the person came here by way of borders, or they just got here without being inspected, parole, or admitted. Well, the BIA is saying that that particular person has no longer the right for a bond hearing once they get detained. They don't have the right to a bond hearing. If they have a case pending, they're just going to wait there until the final decision of the immigration judge. Well, this is bad news. But we're going to talk about how to go around this bad news. For context, okay? People have been here, a lot of people, into the United States without inspection, and they've been continuously living in the United States. And previously, it was held that those people, those individuals, if you have been here for a long period of time and continuously living here, you still have the right to bond. That was previous decision before this current administration. So it wasn't a problem if a person is an arriving alien, as long as that person has been living here for a long period of time. Well, that person really do have a right to a bond hearing. But now, with this matter of Yajure-Explained, the BIA said no right to bond hearings. But here is the thing. What exactly can a person under those type of circumstances, what can that person do if the person gets detained? Well, the person, what they can do, they don't even have to request a bond hearing because it's just going to be denied based on matter of jury. What a person can do, they can just go to federal court in the county or district where they reside. Let's say I live in here in Maryland, let's say in Riverside, Maryland, or Riverdale, Maryland, PG County, Maryland, okay? And I get detained and I happen to enter the United States without inspection. What exactly am I going to do? I am going to go straight to the federal court located in Greenbelt, Maryland, and file for habeas corpus, challenging the ICE detention. And essentially, people are winning because what's going to happen, either you get released or you get a right to a bond hearing where you can actually ask for a bond, and the judge is going to determine based on the standard that they use to apply on bond hearing whether or not you merit release on bond. Okay, that's the solution. People have been winning big, even in Virginia. Some lawyers have reported, because I'm not bar in Virginia, right? But some lawyers have reported that in Virginia, they've been successful with habeas corpus. What you can do if you're looking for a lawyer to file for habeas corpus in Virginia, we can refer you to one. But if you're looking for a lawyer to file for habeas corpus here in Maryland, then yes, you can contact me directly, or you have family members detained, right? You can contact me directly. Consultation link is in the description box below. That's the solution to beat matter of Yajure Hurtado. Habeas corpus, that's it, an action filed in federal court to challenge that detention, that arrest, and really essentially what you're asking is either release or a right to a bond hearing, and people are being successful with those. Okay? Number two, when you get the bond hearing, let's say you go to federal court, you win, and they set a bond, they release you, but they set a bond hearing, right? So that they can determine whether you can be released or not. But because you're challenging the fact that you don't have a bond hearing, but now you go to federal court, they set a bond hearing for you in immigration court. Now you have to meet the standard for the hearing in question. And this applies to people who came without inspection, or those who got here with a visa. The standard in bond hearing is the same for everybody. You have to show that you're not a fly risk and you're not a danger to community. Fly risk. Let's start with fly risk. What are they really looking into? They want to see strong ties in the United States. They want to see that you establish a good work history. They want to see really that you're not most likely to run away, cross the border or go somewhere. When you're filing evidence to show strong ties, or to show that you're not a fly risk, in order to meet the standard, you have to make sure that if you don't have strong ties, to find a sponsor, because we have a better case here at the BIA, is located in Virginia, but we have a better case with BIA saying that, I have to look up the name of the case, but the case says that if the person does not have strong ties, but they have a strong sponsor, someone who's responsible, okay? Someone who can sign on their behalf, they can show a strong sponsor, and that will overcome the burden of showing strong ties. You don't have strong ties, don't worry. You just got here. You haven't established really strong ties, but if you have a sponsor willing to sponsor you, my friend, and that sponsor is a strong tie, has strong tie in America in terms of he has a good job, he has established really a good work employment history, lawful permanent resident or U.S. citizen, that person is going to be your person for the purpose of showing strong ties. So don't discourage, or your family member, if they haven't been here for more than 1 year or 2 years, you can't be discouraged. You just have to find somebody else, a sponsor, okay? And that can overcome that because we have a good case to prove that, okay? Well, danger to community, that's when they look at criminal record. My friend, DUI is the bad one. Unless you can show rehabilitation after being, some people have been, those DUI cases have been dismissed, but you have to show that you've been able to go to counseling, rehabilitation, stuff like that to convince the judge. Otherwise, the judge is going to say, this person is going to get out and start drinking, driving, being a danger to community. Because if you're driving under the influence of alcohol, you are definitively a danger to community, because you can get into a car accident and, people are going to be dying because of you. So unless you show strong rehabilitation, most likely than not, you might not prevail on that bond hearing. But I'm going to give you an example where we're able to prevail on strong tie because we had a sponsor living in the same city. That's always good. Sponsor has to be in the same state than you, right? To show that really you have strong ties, right? Has strong tie. And then to prevail, another example where we had a good sponsor, we prevail on a bond hearing. Another example is that we were able to show rehabilitation. You know, the person was going to a meeting, counseling, and even if you pay fines for whatever the court asked you to do, you did it. And if, let's say, sometimes the conviction has been expunged and stuff like that, you can show that as well. And if a person is going to a bond hearing, the suggestion is that you gather all the evidence because it's a one chance deal. Just go there, get it right. Gather all the evidence. Don't be in a rush to set the bond hearing if you don't have evidence. I have a person who reported to me they filed the bond hearing because they went there lightly. Okay, they're just going there like they're going to a to a shopping center. I'm telling you, like they're just going lightly, and now they wanna reopen the case claiming evidence. But I looked at the evidence. I said those are not new evidence. Those evidence could have been easily discovered before going to a bond hearing. You guys just rush into it. Now you're leaving your fate up to chance, right? So don't do that. Schedule a consultation today using the link in the description box below. When we talk about scheduling, we're not talking about the person's detained. We're talking about family member that we can talk to. They can schedule a consultation. That's how it works. Schedule it. Consultation link in the bio. Until next time, bye-bye.